This is Bloomberg Law with June Grasso from Bloomberg Radio.
The man accused of being the mastermind of September 11th will be spared the death penalty in a deal with the government. On Wednesday, the Defense Department announced that Khalid Sheikh Mohammed and two of his co-conspirators will plead guilty to the murder of 2,976 people in exchange for taking the death penalty off the table. It's a dramatic and, to many, unwelcome development in the prosecution of the deadliest terrorist attack on U.S. soil, a prosecution that's dragged on for more than 2 decades, marred by reports of CIA torture and botched evidence. Terry Strana, the head of 9/11 Families United, says the vast majority of the victims' families are angry about the deal and feel that justice has been denied.
He will not stand trial and he will not face a punishment by death, which is what was on the table. So this is something that KSM and the others wanted. So it's a victory for them. And I don't feel like we should ever give them a victory. This is a sign of a very weak leadership in our country to strike such a deal.
President Joe Biden is distancing himself from the deal, saying in a statement that he played no role in the process. Joining me is national security expert Matthew Waxman, a professor at Columbia Law School. Why have the trials of these 9/11 defendants been delayed for decades?
So right from the start, I think the military commissions that were set up to prosecute detainees at Guantanamo for war crimes have been a failed policy. They were supposed to be set up in order to provide swift justice, but they've delivered anything but that. And I think there have been a number of problems that have slowed down the prosecutions, and especially these that are subject to this plea deal. When detainees were captured, whether on the battlefield or elsewhere, those agencies that picked them up were not preparing a case for trial. They weren't collecting evidence as you would in order to prosecute a criminal trial. There have been issues of evidence or confessions that have been obtained allegedly by torture. There are legal challenges that have been made, some of which have gone all the way up to the Supreme Court, that have slowed down the process. And whenever you set up an entirely new court system, you have to basically develop all kinds of rules and processes from scratch.
Tell us about the alleged mastermind, Khalid Sheikh Mohammed.
So KSM, and he's usually known by those initials, is accused of plotting the attacks of September 11th, 2001. He's one of 30 detainees who are still held at Guantanamo, and he was a U.S.-trained engineer who becomes a key leader of al-Qaeda. And he and two of his accomplices have agreed to this plea deal. They've been charged, among other things, with murdering 3,000 people in the September 11th attacks. And the basic terms of the plea deal are that they will plead guilty to murder and other charges in return for a life sentence rather than the possibility of a death penalty.
I can see what the defendants are getting out of this deal, but what is the government getting out of this deal?
I think it's a good deal for the government, and here's why. I'll be glad to see this case put to rest. I doubt this case would ever have been concluded if it proceeded, and actually carrying out a death sentence would have been a disaster, however much they may deserve it. So let me just say I'm conflicted on the death penalty because these are some of the worst people on earth who've committed unspeakable horrors. But I think actually carrying out a death sentence in this case would have been a disaster. I do feel for families of the September 11th victims who have had to endure the pain, especially of watching this unfold. And I know that they want finality, and many of them are very supportive of the death penalty. But even if it were carried out, and I'm very skeptical that the government would actually have been able to impose the death penalty, I think in this case it would make a martyr of these detainees. I think the story would understandably be that the United States has put to death somebody who's been subjected to torture. That would only add to the terrible stain of Guantanamo and the CIA enhanced interrogation policy.
You mentioned the families. Terry Strada, the head of one group of families, said, I wanted to see a trial, and they took away the justice I was expecting, a trial and the punishment. And Brett Eagleson, president of 9/11 Justice, said, we're deeply troubled by these plea deals. Should the government go ahead with a plea deal that so many of the family members disagree with?
Well, this is a terrible dilemma for the government. And as I've said, I very much feel for the families who have had to endure not just the unspeakable pain of the deaths of their loved ones, but 20 years of this process dragging on. I do hope that they feel some sense of justice, but there are other very powerful concerns and interests at stake here, and the U.S. government has to do what's right, taking into account all of these various factors. As I said, I don't think the death penalty ever would have been carried out in this case, and I think the death penalty would have carried immense damage to United States interests, especially abroad.
Why is the government not releasing the details of this? Might it be because some of the details might be objectionable?
I suspect some of the details are still being worked out. I think some of them will need to be approved by the military commissions and through some other processes. But this is also one of the challenges of moving a case like this through a military justice process that hasn't really been tested. A lot of what's going on in military commissions is new. And so we don't know for sure how some of these processes are going to play out. That's been one of the problems plaguing military commissions from the beginning, is that this is an untested process.
And 2 of the 5 other 9/11 defendants are not part of this plea deal?
That's right. For several years now, it's been reported that a deal like this has been in the works, some sort of plea deal for a life sentence in return for pleading guilty rather than the possibility of the death penalty. Originally, it was talked about as possibly involving 5 of the direct perpetrators or leaders of the 9/11 attack plot. I don't know why we're now talking about a deal involving only 3, but over the course of the last few years, we've heard that this deal is sort of on again, off again, and so there are any number of possible reasons.
Looking at the big picture here, the government is disappointing most of the family members with this deal. They're getting a life sentence for the murder of 3,000 people, and the deal only covers 3 out of the 5 suspected terrorists. Even the president is distancing himself from the deal. So after more than 20 years, doesn't this seem like a complete failure?
So right now, there are 30 detainees out of a total of roughly 800 who were brought to Guantanamo since it opened in 2002. Most of them have been transferred or released, some of them to their home countries, some of them to third countries with varying restrictions. Some of them were transferred for continued detention, for example, in their home countries. Of those who remain at Guantanamo, about half have also been approved for some sort of transfer, but we don't know whether that will happen anytime soon. A few, though, will never be charged. They're going to be held indefinitely without any sort of prosecution. I think Guantanamo has been a failed policy. It was originally opened to be a place that would hold only the very worst of the worst. And it turned out that many detainees who were brought there should never have been. Either they were cases like mistaken identity, or they were low-level al-Qaeda or Taliban figures. It was also supposed to be an interrogation and intelligence center where the government would be able to obtain a vast amount of information about future al-Qaeda plots and networks. And I think it failed in both its detention mission and its intelligence mission. That doesn't mean that it was not valuable in some important ways. It kept many very, very, very dangerous people off the battlefield and prevented them from conducting further attacks. It also did provide some important intelligence information, never as much as I think was expected, but it did provide some very, very important information. But from the beginning, there was never really a good plan for what was going to happen to the detainees long term. There were insufficient processes put in place for figuring out which detainees should be detained there and which ones shouldn't. It is indelibly associated with this idea of a legal black hole and with torture. And I think many of those costs continue to accrue over time.
Former Attorney General Eric Holder told NBC News that, quote, the people responsible for structuring this awful deal did the best they could. He said they were dealt a bad hand by the political hacks who blocked the trial of accused September 11th terrorists in federal court nearly 15 years ago.
As of today, only one detainee from Guantanamo was brought into the United States for prosecution in federal court here in New York. It was thought in the Obama administration that they would be able to bring many more, but that plan was shut down really for political reasons. There was a lot of opposition in Congress, which then put restrictions on transferring any detainees out of Guantanamo and barring bringing them into the United States. But this also gets to a broader problem, which is it's very easy to say that Guantanamo is a mistake. Guantanamo should be shut down. But it's very hard to figure out what should you do instead. And just saying we should bring them into the United States for prosecution wouldn't work. Just saying you should send them back to home countries or third countries wouldn't work. It's very, very hard to figure out what's going to happen to the remaining 30 detainees at Guantanamo. The government has been working hard to shrink that number even further, but it's very hard to figure out what is a viable alternative to holding them at Guantanamo. And I think part of this goes back to the very beginning, that it wasn't designed with really long-term thinking in place.
I do want to mention that there will be a sentencing hearing for the 3 defendants, and we may learn more then. Thanks so much for being on the show. That's Columbia Law School professor Matthew Waxman. I'm June Grasso, and you're listening to Bloomberg.
Inside the NBA is the benchmark, the ultimate studio show.
One of the greatest sports shows of all time.
I put Inside the NBA above everybody else.
You never know what to expect.
We have more fun at TNT, and that's what makes it special.
But it looks like the widely acclaimed sports show will not be on TNT after 2025 unless a lawsuit changes things. The NBA signed a new TV rights deal with Amazon, NBC Universal, and Disney, worth about $76 billion over 11 years, and leaving TNT out in the cold. So TNT's parent company, Warner Brothers Discovery, is suing the NBA for breach of contract, saying the league rejected its matching offer. Charles Barkley, one of the co-hosts of Inside the NBA, was as outspoken as usual about the league's new deal on the Dan Patrick Show.
This was a last-ditch cash grab by the NBA and the players. That's why I think they signed an 11-year deal. So they're like, hey, let's get as much money as we possibly can right now. This is going to be our last bite of the apple, because TNT, ABC, ESPN, they're not going to pay more money going forward.
The lawsuit is another chapter in the deteriorating relationship between the NBA and Turner Sports, a relationship that's lasted nearly 40 years. Joining me is entertainment and media lawyer Ronald Beanstock, a partner at Scorinci Hollenbeck. What happened here as far as you can make out?
There's a lot of redactions in the complaint, so it's kind of hard to know some of the specifics of the agreement, but I will tell you what I think happened. So this is really a fight between tech corporate structure looking to find their way into the larger dollars of entertainment properties, and you can't get any bigger really than sports, versus old school broadcasting. You've got a company, TNT here, who has had the right for 40 years within their agreement with the definition of the word match right a commonly used part of entertainment agreements where somebody who has rights to something would like to keep those rights to something, but they allow a third party to come in, make the offer, and they get to match. And then, you've got a usurper, if you will, a tech company, Amazon, obviously Disney, that comes in and says, I want to make a really great offer to you. I'd like to bring this asset to our camp, and we think we can do really well with the billions of dollars every year. We think we can enhance the NBA's income and enhance ours. Obviously, bring bigger and better advertising dollars to their format and subscriptions, and we'd like to make an offer on this. Somewhere, they made that offer, right? The timing was correct. They made the offer, and TNT had to, quote, match. So TNT says we matched. We matched timely. That's not in dispute. Seems to be all done correctly. But Amazon is saying, and apparently NBA is saying, no, you didn't. You didn't match according to the agreement. We have other services or other things we can offer. You didn't match that. You're only matching the initial offer. And that definition of match is one of the crucial discussions with billions of dollars at stake.
I mean, what's the general interpretation of what match means in a contract like this?
So in entertainment businesses like this, the match would be first right, like a first right of refusal. And the definition, I'm not clear about, no one's clear about because its contractual language has been redacted from the complaint. But there's a real difference here. And that is the difference would be between I get to match and the words that are used in the complaint as an incumbent, which is not a commonly used word in entertainment property agreements, incumbent. Because it says as an incumbent, TBS has the right to match any, quote, third-party offer, end quote, for future NBA telecast rights. Right to match any third-party offer, which would indicate to me that it's an initial match right. If someone says 200 and I say, I'll give you 200, I'll match that. Now it stays with me. I am, as they call it, the legacy or incumbent here. I'm the legacy licensee. I would maintain my rights. The term length of the next portion of this agreement is 11 years. That would be over 50 years of retaining rights in terms of a licensee to a piece of property like this. And that's probably where everybody is fighting this because the tech companies think they could probably do a better job. So the word match looks like initial match. Many times when we're negotiating entertainment property agreements like this, music business is a good example, music publishing, record deals, or things of this nature, licensing deals, we have last match. That's a preference of mine because if you say 200, but that's not the fully ending negotiated deal, I think I can get you to 3. I don't want you to match 2. I want you to match the deal I'm willing to execute. That would be what the match right should say. I don't know because it's been redacted. So we'll have to find out as discovery goes on.
In the new TV rights deal, national games will be distributed across Amazon Prime Video, NBC's broadcast network, Peacock's streaming service, and Disney's ABC and ESPN platforms. And it's not just matching the money, is it? It's also matching the scope.
Yes, I think that's part of the process. And I think the match is the scope. What can we offer in terms of SVOD, subscription video on demand? I think this is all within the concept of the match. I don't think the match was one sentence. I don't think it says, here's the money, match it. I think structurally it's the scope, clearly territories worldwide, but it's scope in terms of what we have to offer and what platforms. I think that's a part of this. I think that they're trying to say you're an old school broadcaster, but TNT has other platforms that they get to put it on through Mac. So I think these are parallel universes colliding. I don't know if they're exactly in the same size universe, but I think that they are structurally similar because Max allows the similar version of platform structure as Amazon would have as well.
Suppose this is about the NBA saying, this new deal is just better for our brand long term. Where does that fit into the equation?
Someone is looking at this in a long-term process, right? Someone's saying this is better for us in terms of the NBA brand and our largesse in the future. Clearly, that's what's at stake here. Somewhere in that agreement between TNT and the NBA, this 40-year, that's a lengthy relationship, which apparently, according to whatever I've seen in the press and people that I know, has not been the best in the past few years, that there's been a lot of discussion about this, and again, I'm going to reiterate that point about tech giants versus old school broadcasters. There seems to have been a exclusive negotiation period that was the precursor to this match. So it looks like there was some, over the last year, contractually, they were obligated to have not mediation, but a negotiation where they would sit in that room and they would try to knock out their new agreement. And it didn't work. somewhere in the NBA, a team of people in the NBA or the owners, whoever was involved, said, no, it's not structurally sufficient. We think we can do better. We think the NBA brand can do better at this different set of platforms. But they had that moment, and it didn't work out.
Warner Brothers is asking for a jury trial. Is it difficult to line up two different offers like this for a jury when it's not just a question of money?
I don't think it's that sophisticated. Look, this jury trial demand, yes, but think about what we've got here. We've got in the request for injunctive relief, specific performance. But if we get to a jury, this to me looks like you can put the two offers up on, large boards in front of a jury and go, there's their offer, here's our offer. Look at ours. You see, we match that. There it is. It's not difficult areas of law. It's going to be, how do you define match? And did we do it? Getting to that, though, oh, my goodness, we have a long way to go. We have all this other stuff we're going to have to go through.
Interesting that Turner, in its complaint, said that we strongly believe that this is not just our contractual right, but also in the best interest of fans who want to keep watching our industry-leading NBA content.
They've come to think of it as their own. The property they call their asset, which they shouldn't be calling its assets, but they do in that complaint. And that's very telling. They have a large investment in the NBA broadcasters and experts and color commentators. That's a lot of money they've got invested. And they've been very successful with that. I think they've won their own Emmys. I think that's a huge part of this, that they say, look, we pay Charles Barkley X, and we have the best people to do this. Now, who are you going to bring on to do this, right? Look how we've invested into this. And I think that's part of this. And I think that what they're trying to say in the complaint is that we've got so much invested, and look at the terrible losses we'll suffer. Well, I have a hard time. I mean, that's 40 years. Did you do everything in the 40 years? I think that's going to come up, right? They're going to say they got complacent. Sure, they had this great team of experts, these really popular hosts. It's interesting to see in the complaint. I want to say it's a woe is me kind of thing, saying how terribly we'll be hurt. Sure, that's what complaints say, but that's not the point here. It's, did you match it? Did you follow what they had said? I also want to know what went wrong in that exclusive negotiation period. What happened there? And ultimately, if it doesn't work out, there may be a split the baby here. It is state court, it is state supreme in New York, so this won't be the first time anybody does something like this. They may say, you know what, for the first 3 years, we may give key games to stay with TNT and their team, and then regular season games X, Y, and Z will go over here, and then eventually we're going to morph this all entirely over to the new licensee. That may be how this gets done. Nobody's going to want to have this extend past even the preseason. So I think they're going to have to figure out methodologies to compromise at some point. It's not like they're going to postpone the season. So I think that the issue is going to start to come up pretty fast and furious. There's billions and billions at stake here.
Are courts reluctant to force someone or a party into a deal they don't want to be in?
Yes. Simplest answer I can give. Yeah. That's a common discussion in entertainment properties. If an artist wants off a label, the judge is going to say, how you guys getting along? Oh, terribly? Okay, no, I want you guys back together. Shake hands. Come on, you can put it back. Never happens. It never happens that way. There's always some override, similar to the theory here of certain games being split up. There may be an override on structure of money. There may be a way to, you owe 2 records to this person. Oh, you owe 5 songs to this publisher. Oh, you owe 12 episodes to the original production company. Yeah, we do that to get through the process so we don't kill the golden goose here. Entertainment properties take decades, if not lifetimes, to develop like this, and so nobody wants to hurt that. So I think that there are going to be ways we get this resolved that may not be in the standard methodology. I think there's going to be a lot of meetings in chambers. I think there's going to be a lot of meetings with everybody just discussing how to make this work.
So it sounds like you think there'll be some kind of settlement before this ever gets close to a jury.
I think there's a possibility there's going to be a series of workarounds to try to satisfy some immediacy for TNT, but I think eventually there's going to be a transition unless everything has gone wrong from the Amazon point of view in terms of where the match was and how you define match. And it sounded like something happened in that definitional process. Somebody says, we did it. The other side, NBA, is saying, no, you didn't do that. Is it based upon, as you and I just discussed, the variable platforms and the extensive nature of the other digital platforms? It's hard to know. The redactions make it hard to know because at the end of the complaint, June, there is a series of redactions where it's effectively saying the Amazon offer They did something here that wasn't in good faith. It's a bad faith effort to deprive TBS of its contractual rights. They found a way around it. That's pretty hefty. We don't know what the language was, but they're saying they caused the match to be rejected. Has to be proof of that. What did they do? Where is that enter? What did they do? What was so crafty about these guys that they were able to convince them that they could get around the match right? That's redacted. We're going to have to go find out once this proceeding really gets rolling.
That certainly adds to the drama here. Thanks for coming on the show. That's Ronald Beanstalk of Scorinci Hollenbeck.
These scandals involving the justices have caused public opinion to question the court's fairness and independence.
The public's confidence in the Supreme Court has fallen to historic lows following a series of controversial rulings that overturned landmark decisions on abortion rights and federal regulatory powers, established the right to carry a handgun in public, and determined that former presidents have broad immunity from prosecution. So with less than 6 months left in his presidency, Joe Biden is calling for dramatic changes to the court that have no chance of being enacted.
We need these reforms to restore trust in the courts, preserve the system of checks and balances that are vital to our democracy. They're also common sense reforms.
Common sense? Perhaps. Controversial? Definitely. Joining me is William Traynor, Dean of Georgetown Law and a constitutional history scholar. Let's start with Biden's proposal for term limits for the justices. A president would appoint a justice every 2 years, and that justice would sit 18 years on the court. This isn't a new idea, but could it be done through legislation, or would it take a constitutional amendment?
No, this is not a new idea. At the start of his administration, President Biden appointed a commission to look at the possibilities of Supreme Court reform. And this is one of the proposals that they made. So it's something that people have been focusing on for a number of years. And there's a debate about whether it would require a constitutional amendment. I think it should be constitutional because historically, the duties of Supreme Court justices have not always been the same. And so this is similarly just altering what the duties of Supreme Court justices would be. But again, that's something that people debate.
Yeah, some argue that the term limits proposal is at odds with Article 3, which provides that justices shall hold their offices during good behavior.
So one of the questions is this consistent with the original understanding? And I think it is. One of the changes that we've seen over time is Supreme Court justices are now on the court much longer than they were at the beginning. So if you look at the Washington administration, for example, the average tenure of the justices he appointed was less than 8 years. Whereas now, the most recent departures from the court, either through death or resignation, have been about 30 years. So this is dramatically different than what was envisioned at the start. And it also means that there's a tremendous amount of luck in terms of which president controls the justices on the court. So, for example, Jimmy Carter in 4 years had actually no appointment, whereas in the same period of time, Donald Trump had 3 appointments. So one of the things that Biden's proposal would do is essentially take the luck and the happenstance out of appointments to the court by saying that every president would have an appointment every 2 years. So that really would bring, I think, the makeup of the court much more in line with what people determine in the presidential election. So I think this would make sense.
Biden is also calling for a binding ethics code that would require the justices to disclose gifts, refrain from political activity, and recuse themselves from cases presenting conflicts of interest for themselves or their spouses. Now, Democrats have been trying to pass an ethics code to no avail. But are there any constitutional problems with an enforceable ethics code?
Well, I don't think there's a problem with this. For example, we have binding codes of ethics for people in the executive branch. It's really the same thing. Congress here would be creating an ethical framework for Supreme Court justices. So it seems to me that it's something that Congress should be able to do. But again, this is something that is debated. And there's some people who will say, for example, Justice Alito has said, this would not be constitutional.
But the Constitution states that the Supreme Court's jurisdiction must be exercised under such regulations as the Congress shall make.
Well, the question is whether this is the kind of regulation that the Constitution has contemplated. And again, this would be a new question. The Supreme Court has never been subject to congressional rules like this. But as a legal matter, the question is whether this would fall into the Constitution's text about regulation. And that's really debatable. I think it would, but again, Justice Alito has said that it would not. And it would ultimately be a question for the court.
Well, that seems to be the catch-22 for both this proposal and the term limits proposal. Both ultimately would end up at the Supreme Court, and the justices would be the arbiters of whether they're constitutional or not. And how much would an ethics code really accomplish? It would stop them from accepting gifts, get them to recuse from a few cases, but it wouldn't make them any less partisan in their decision-making.
The argument would be that when they're accepting gifts, it affects the way in which they think about cases. So it's not partisan directly, but I think underlying the idea of an ethics code is the idea that when you receive gifts, it tends to color your point of view. And so the ethics would take that out of the equation.
I don't know if he has, made any very specific suggestions, but this would be enforceable by whom?
Well, I think that's a question. So what's the mechanism for enforcement? One of the suggestions that people have had is that you would put together a panel of lower court judges who would decide what's appropriate and what's not appropriate. So it would take it out of the Supreme Court deciding for itself and give it to other federal judges. If this were to go forward, and it's not going to go forward with this Congress, but if it were to go forward in the future, I think that is the most likely framework.
Then he's calling for a constitutional amendment to ensure that former presidents can be tried for crimes committed while in office. Amending the Constitution is virtually impossible these days. It requires approval from 3/4 of the states.
Well, it's incredibly hard, but it's incredibly hard really for most of American history. I think this does two things. One is it's a symbolic statement, and it's also an indication of disapproval of the Supreme Court's decision in Trump versus the United States. So I think it's unlikely that this would be adopted, but it still is a very powerful statement.
Biden didn't include a couple of things that have been proposed at various times, one being packing the court or adding more justices to the court. And that doesn't have the legal problems that his other suggestions have. It's allowed by the Constitution.
That's right. Congress has the ability to establish the number of justices on the court. So right now we have 9, and we've had 9 for more than 150 years. But that's not written into the Constitution, and we've had different numbers of justices over time. So we've had as few as 5, and we've had as many as 10. So there's really no constitutional problem with creating more justiceships. The reason why he didn't do that is that that would feel very partisan. So, for example, if you were to have 3 more justices that a Democratic president would appoint, then there would be a taint about those justices. And almost inevitably, the next time you had a Republican president, a Republican Congress, it would be expanded even more. So he has proposed something that's not packing the court, but is really designed to be, I think, nonpartisan, to give every president moving forward 2 seats. And on top of that, also to say that the justices on the court will have lifetime tenure. So it will not alter short-term the court's makeup. There's 6 Republican appointees, 3 Democratic appointees. It would be a very long time before you could conceivably have, under President Biden's formula, a shift towards a Supreme Court in which most of the appointees were Democratic.
Another widely discussed reform that Biden didn't propose is called jurisdiction stripping, and it is constitutional. So why do you think Biden left that out?
Right. So Congress has substantial control over the jurisdiction of the court. So at various times in the past, it's taken certain issues away from the Supreme Court. And that's what we call jurisdiction stripping. But that's not something that his proposals call for. And I think that's really not been something that has been at the top of the debate. His proposals really track the things that people are focusing on now. Some kind of expansion of the court, some kind of ethics code, and then also in the wake of Trump versus the United States, a constitutional amendment that would lead to a different result and that would provide that presidents can be prosecuted. Which, before the decision in Trump versus the United States, that's been something that has been assumed throughout American history. I worked on the Iran-Contra investigation, and the focus was on whether President Reagan was guilty of criminality. And during the course of that investigation, there was really no argument that you shouldn't be considering presidential criminality. Same thing in Watergate. So the Trump versus United States decision is something that really represents a departure from something that has been assumed to be the case, really all the way back to the times of the founders.
During his term, Biden resisted calls from progressives to seek reform to the Supreme Court. Why now, with 6 months left in his term?
Well, I think he wants to make a statement as his presidency is drawing to a close that he thinks the Supreme Court is off the rails in a lot of crucial areas. And I think he didn't act before now because this is cumulative. What he's seeing over time is there are more and more decisions in which the court is departing from the original understanding or departing from precedent. And I think Trump versus the United States might have been the trigger for him. That is a decision where I think he would say that the court has taken a position that's really, at odds with principles of the rule of law, and some step has to be taken to address that. At the same time, I think it shows a tremendous amount of restraint because what progressives were pushing for when he came into office and have been pushing throughout is expanding the number of justices. And he hasn't done that. He's gone forward with something that's, I think, both more nuanced and more respectful of partisan balance. It's really much more nonpartisan because it would give to every president 2 appointments for every term. So that's not a partisan result, but it does reflect the idea that you should move away from that kind of 30 years on the court, which is what we're seeing now, and move to something that is much more like, I think, what the founders envisioned.
A recent Annenberg report finds, quote, a withering of public confidence in the court, and all the polls basically show the same thing. Has there been another time in history when there's been this crisis of confidence in the Supreme Court?
The most prominent time in which there's been a crisis of confidence in the Supreme Court was during President Franklin Roosevelt's administration. The court struck down many crucial pieces of New Deal legislation. So there was tremendous concern about the court. Now, President Franklin Roosevelt pushed it too far. He tried to pack the court, and that generated a lot of opposition. But that's the period in which, most recently, we've seen incredible concern about the Supreme Court, and I think a sense that it was out of step with popular will. This is a time in which there is a concern about the court in a way that we have not seen for almost 100 years. So the significance of President Biden's proposals is that it's part of a focus on the court, which, again, I think is new within the lifetime of virtually every American.
Thanks so much for your insights, Dean. That's Dean William, trainer of Georgetown Law. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.